My husband divorced me at 74, taking our $3.8 million house. You will never see the kids again, he laughed in court. I walked out with $285,000 and a shattered life. But then I found the emails. Proof he'd been hiding assets for months before filing. I hired a new lawyer and fought back. Good day, dear listeners. I'm glad you're here with me. Please like this video and listen to my story till the end. And let me know which city you are listening from. That way, I can see how far my story has traveled.
Let me take you back to the beginning. My name is Evelyn Grace Thornton. I was 74 years old when the ground beneath my feet began to shift. My husband, Richard Rick, to everyone who knew him, was 76. We had been married for 48 years, since 1976, when I was 26 and he was 28, and we stood on Cannon Beach with the Pacific crashing behind us, while he promised to build a life with me the way he built bridges, something that lasts, something that carries weight. We had 3 children: Andrew, who lived in Denver with his wife Claire and their twin daughters; Rebecca, in Seattle, a hospital administrator with a careful, controlled way of speaking that I recognized as her father's; and Jennifer, also in Seattle, a graphic designer with her father's precision and my love of color. 6 grandchildren between them. Every Thanksgiving, the house on Laurelwood Drive smelled like roasted Dungeness crab and sourdough bread and hazelnut pie. That was the life I knew. That was the life I thought was permanent. The house itself was a Craftsman built in 1925, 3 bedrooms and a study, a wide front porch with a swing, and a cherry tree in the yard that Rick had planted the day we brought Andrew home from the hospital in 1978. He had stood in the front yard with the sapling in his hands and said, "This tree will be here when he graduates, when he gets married, when we're grandparents." I had believed him. I had believed everything he said for 48 years. That was my first mistake. The morning Rick told me he wanted a divorce. It was late February. The rain was falling soft and steady the way it does in Portland in winter, and I was sitting at the kitchen table with a cup of tea, reading the news on my iPad. Rick came downstairs, poured himself coffee, and sat across from me. He folded his iPad into landscape mode, he always read it that way, and set it down carefully. Then he said, "Without looking at me, Evelyn, I want a divorce. My attorney will be in touch." I had not seen it coming. That is what everyone asks later, in the careful voices people use when they want to know if you were complicit in your own blindness. Had there been signs? Yes, there had been signs. In October, 5 months before that morning, I had gone to the Fred Meyer pharmacy to pick up Rick's blood pressure medication and my own. The pharmacist told me Rick had called ahead to change the billing address on his account, not ours, his. A post office box in Lake Oswego I had never heard of. I told myself it was a mistake. Rick was 76. He had been diagnosed with atrial fibrillation and early-stage congestive heart failure the previous April. These things happen. Memory slips. Administrative confusion. But then I noticed he had started closing his laptop when I entered a room. Rick, who had spent 35 years as a structural engineer and had never been precious about his computer, was suddenly protective of the screen. He took phone calls in the garage. He began driving to the hardware store on Saturday mornings and returning 2 hours later without a single bag. Once, I smelled perfume on his jacket collar. Something young and synthetic, nothing I recognized. I said nothing. I am not by nature a dramatic woman. I watched, I listened, I told myself there were explanations. We had been through difficult seasons before. The year Andrew's firm nearly failed. The year I had a cancer scare that turned out to be nothing. We had always come through. But in December, I found a birthday card in the glove compartment of Rick's truck. I had been looking for the registration after a minor fender bender in a parking lot, and there it was, tucked beneath the insurance papers. It was a birthday card for Rick's 76th birthday, which had been in November. The handwriting was feminine and careful. It said, "Every day with you is a gift, L." I stood in the driveway of the house on Laurelwood Drive, the house Rick and I had bought in 1987, the house where I had raised 3 children and hosted countless Thanksgivings, and tended a garden that had once been written up in the neighborhood newsletter. And I felt something cold pass through me. L. Just a letter. but a letter is enough to end a world. I said nothing that night or the next. I cooked dinner. I watched the evening news beside him on the sofa. I smiled when he made jokes about the dog, our Irish setter named Justice, who had a habit of lying in doorways like a judge presiding over the household. And all the while, I was memorizing his behavior the way you memorize a map when you know you are going to need it. By February, I had confirmed what I already knew in my bones. Rick was seeing a woman named Lisa Brennan. She was 51 years old, an interior designer and stager from Lake Oswego. I found her name through a restaurant receipt I discovered in the recycling bin. A receipt from the Stephanie Inn, a luxury resort on Cannon Beach, for a $340 dinner for two on a date I had not been there. The same beach where Rick had proposed to me 48 years earlier. When I tried to speak to him about it quietly, one Sunday morning in late February, just the two of us at the kitchen table, he did not deny it. He looked at me across the breakfast table, the same table where we had eaten thousands of meals, and he said with a calm I had never heard from him before, "Evelyn, I want a divorce. My attorney will be in touch." That was all. No explanation, no apology, no grief on his face. 48 years. And he said it the way you'd cancel a magazine subscription. I asked him why. My voice was steady, though my hands were not. "I'm not happy," he said. "I haven't been for a long time." I wanted to ask, "How long? When did you stop being happy? Was it before or after you met Lisa Brennan? Was it before or after you changed the pharmacy billing address? Before or after you took phone calls in the garage? Before or after you ate a $340 dinner on the beach where you proposed to me?" But I didn't ask any of that. I simply nodded. I stood. I walked out of the kitchen and into the study where Rick's cherry tree was visible through the window, its branches bare in the February rain. I thought about the day he had planted it. Andrew had been 3 days old, wrapped in a blue blanket, and Rick had knelt in the dirt with the sapling in his hands and promised the tree would be there for graduations, weddings, grandchildren. And now he was leaving, and he would take the tree with him. What followed was 7 months of legal proceedings I was wholly unprepared for. Rick had retained a team of attorneys, not one but 3, led by a man named Graham Sullivan, who specialized in high-asset divorce and asset protection. I later learned that Rick had begun restructuring our finances 18 months before he filed. The house on Laurelwood Drive, valued at $3.8 million by that point, had been quietly transferred into an LLC he had formed, without my knowledge, Laurelwood Properties, LLC, registered in Nevada. Our joint savings account had been reduced to a figure that barely covered 2 years of modest living. I hired an attorney of my own, a kind but underpowered man named Paul Henderson, who had handled mostly family law and minor estate work. He did his best. It wasn't enough. The day of the final hearing, in March of the following year, Rick sat across the courtroom looking healthy and calm. Lisa Brennan was waiting in the hallway outside, I was told later, though I never saw her. When the judge finalized the settlement, giving Rick the house and leaving me with $285,000 after attorney fees, Rick turned to look at me, and he laughed. It wasn't a loud laugh. It was quiet and satisfied, the kind that doesn't need an audience. Then he leaned toward me, close enough that only I could hear, and he said, "You'll never see the kids again. I've made sure of that." I did not cry. I sat very still, my hands folded in my lap, and I looked at him, this man I had loved for over half a century, and I memorized his face the same way I had memorized everything else. Then I left the courthouse, got into my car, and drove 3 hours south to my sister's house in Eugene, Oregon. My sister, Catherine Kate, to everyone who knew her, was 69 years old, widowed, and she lived in a small farmhouse outside Eugene that smelled like wood smoke and lavender. She opened the door before I even knocked. She always knew when I was coming, the way older sisters do. I stayed in her guest room. I slept badly. I ate toast and soup and let her 2 cats sleep on my feet, which helped more than I expected. I made lists. That was always how I processed things. I made lists. On a yellow legal pad I found in Kate's kitchen drawer, I wrote down everything I had lost. The house first, Laurelwood Drive, the wraparound porch, the cherry tree, then the money. Our joint savings account had been drained legally, through Rick's restructuring, and my share of the settlement came to $285,000 after attorney fees. That sounds like a sum until you are 74 years old, with no income, no property, and the medical expenses that come with age. Then I wrote down the children. Andrew had called me once after the hearing. He said, "Mom, Dad explained everything. I think you need to give him space." He hung up before I could respond. Patricia Rebecca, I reminded myself. She'd always gone by. Rebecca had not called at all. Susan Jennifer sent a text message. It said she was staying out of it. These were my children. I had sat with every one of their fevers. I had driven them to soccer practice and SAT tutoring in emergency rooms. I had loved them without condition for decades. And they were staying out of it. I wrote their names on the list too. Not out of bitterness. Not yet. Just to acknowledge what was real. For the first 2 weeks, I told myself I simply needed to survive, find a place to live, figure out the money, breathe. Kate offered to let me stay as long as I needed, and I was grateful. But I also knew that Kate's house was Kate's life. And I was not a woman who survived by borrowing someone else's space indefinitely. But somewhere in the third week, while I was sitting at Kate's kitchen table with my legal pad and a cup of tea gone cold, something shifted. I had been so focused on what had been done to me that I hadn't stopped to ask a different question. What had been done exactly? And was it legal? I am not a lawyer. I never finished my degree. I left college in 1976 to marry Rick, which was what women did then, a decision I made freely and never fully regretted until now. But I was not unintelligent. I had taught high school English for 32 years. I had managed our household finances. I had balanced budgets and negotiated with contractors. And the more I thought about the timeline, the LLC, the account restructuring, the 18 months of preparation Rick had done before filing, the more I thought, Paul Henderson never looked closely enough. I called Paul from Kate's kitchen. He was polite and sympathetic and confirmed that he had reviewed Rick's financial disclosures as filed. I asked him one question. Had he independently verified that the asset transfers to the LLC preceded Rick's intention to divorce? Or had they happened after the decision was made? Because if Rick had transferred marital assets after deciding to seek divorce, but before filing, that could constitute fraudulent transfer of marital property under Oregon law. There was a long pause on the line. "Mrs. Thornton," Paul said, "that's a very specific question." "I know," I said. "Can you answer it?" He could not. He had not looked. That was the moment my plan was born. Not out of anger, though anger was there, steady as a pilot light, but out of something colder and more useful. The recognition that the game had not been played fairly and that unfairly played games could sometimes be replayed. I needed a different attorney. I needed someone who understood asset concealment and fraudulent conveyance in the context of divorce. I needed financial records I didn't currently have. And I needed, most importantly, to understand what Rick had actually done. Not what he had claimed on his disclosures, but what he had actually done. I opened my laptop, the small one I'd bought myself 3 years ago, to video call the grandchildren, and I began to research. I found the name of a firm in Portland, Diana Reeves, a lawyer who specialized in high-asset divorce litigation with a focus on financial fraud. Her website said she had spent 20 years as a white-collar crime prosecutor before going into private practice. I found that Oregon law allowed for post-judgment motions if fraud could be demonstrated in the original proceedings. I found that LLC transfers made within 24 months of a divorce filing could be scrutinized if the intent to defraud could be shown. I wrote all of this down in my yellow legal pad in my careful, even handwriting. Then I called Diana Reeves's office and made an appointment for the following Tuesday. I told Kate that evening over dinner. She set down her fork and looked at me with an expression I recognized, the same one she'd given me at 17 when I told her I was going to audition for the school play, despite being terrified of audiences. "You're going to fight him," she said. It wasn't a question. "I'm going to find out the truth first," I said, "and then I'm going to fight him." Kate reached across the table and took my hand. "Mom would have been proud of you," she said quietly. I had to look away after that. Not because it hurt, but because it was too large to receive all at once. That night I sat in the guest room and thought about the cherry tree. The one Rick had planted the day Andrew was born. The one he had promised would be there for graduations and weddings and grandchildren. He had kept the tree. He had kept the house. He had kept everything, except the truth. And the truth, I was beginning to understand, was the only thing that mattered. The drive to Portland took just over an hour from Kate's house. I wore my gray wool coat, bought years ago for a faculty dinner at Lincoln High, because I believed in showing up to serious meetings as seriously as they deserved. I had my legal pad, a folder of every document from my original divorce proceedings, and the receipt from the Stephanie Inn I had kept folded inside my wallet for months. Diana Reeves's office occupied the 8th floor of a building on SW 5th Avenue, with a view of the Willamette River. The attorney who met with me was not what I expected. She was 47, with dark hair pulled back in a simple knot and the kind of stillness I associated with people who spent their days in rooms where a great deal depended on staying calm. She shook my hand and did not speak to me the way some younger people speak to women my age, with that slight elevation of volume and simplification of vocabulary. She simply asked me to start from the beginning. I did. I talked for almost 90 minutes. She took notes. She did not interrupt, except to ask precise, useful questions. Exact dates, dollar amounts, names of entities. When I finished, she sat back and looked at what she had written. The LLC formation date? She said. Do you know it? I know it was registered in Nevada, I said. I don't know the exact date. That's the first thing we need, she said. If it was formed after Rick made the decision to divorce, and there are ways to establish that, you have grounds for a fraud claim that could reopen the settlement entirely. What would that require? I asked. A subpoena for his financial records, the LLC's formation documents, his attorney-client communications to the extent they reveal intent. She paused. This is not a fast process, Mrs. Thornton, and Rick will fight it. I know, I said. He has resources. So do we, she said simply. I retained Diana Reeves that afternoon. It cost me $8,000 up front, nearly a third of what I had readily accessible, and I paid it without hesitation. Some expenditures are not expenses. They are decisions. Diana filed the post-judgment motion within the week, citing potential fraudulent conveyance and requesting full discovery of Rick's financial records from the prior 36 months. The motion was accepted by the court, and formal discovery notices were sent to Rick's attorneys. I know the moment Rick found out because Andrew called me. It was a Thursday evening, and I was back at Kate's house eating leftover chicken soup when my phone rang with Andrew's number. The first time he had called since that single disappointing call after the hearing. His voice was tight in the way it got when he was performing calm over agitation. Mom, he said, Dad says you've hired new lawyers. He says you're trying to reopen the divorce. I filed a post-judgment motion, I said. That's accurate. Mom, a breath. This is just going to drag everything out and cost you money you don't have. Andrew, I said, did your father ask you to make this call? Silence, which was its own answer. Tell him I said hello, I said, and I ended the call. After I hung up, I sat quietly for a moment in Kate's kitchen and recognized what had just happened. Rick had reached out through our son, a man I had raised, to pressure me into dropping a legal action. He had recruited Andrew as a messenger. The implications of that were not lost on me. The evidence came 6 weeks later, delivered in a thick envelope from Diana's office. The LLC, Laurelwood Properties LLC, had been incorporated in Nevada on April 22nd. Rick's divorce filing had been submitted to the court on August 18th of the same year. That 4-month gap seemed to suggest on its face that Rick had planned the transfer in advance. But the document that mattered most was a series of emails recovered during discovery. Communications between Rick and his lead attorney, Graham Sullivan, dating from the previous February. In those emails, Rick had written explicitly, I need the property secured outside the marital estate before I file. Lisa says the Portland market is peaking, and I want to move quickly. February. 6 months before he filed. While we were still sleeping in the same house, eating at the same table, watching the evening news side by side on the same sofa. I read that email sitting in Diana's office on a gray February afternoon, and I felt something crystallize inside me. Not rage. I had moved past rage into something more architectural, a structure of intention that was solid and load-bearing. Is this enough? I asked Diana. She allowed herself a small, controlled smile. "It's a very good start," she said. I walked out of that building into the cold Portland air and stood on the sidewalk for a moment, breathing it in. Was this the moment everything changed? In some ways, it already had. Rick had thought he was dealing with a woman who would grieve quietly and disappear. He had miscalculated, the way powerful people often do, by assuming that age and loss had diminished me. They had not. Diana moved quickly after that. She filed a formal motion to vacate the divorce settlement on grounds of fraudulent conveyance, attaching the emails as Exhibit A. She also filed a separate request for a temporary injunction preventing any sale or further transfer of Laurelwood Properties LLC assets while the motion was pending, which meant Rick could not sell the house or move money out of the entity while the case was active. The injunction was granted within 72 hours. I heard nothing from Rick directly. What I heard came in pieces, through channels he had apparently decided were safer for him. The first came from Rebecca. She arrived at Kate's farmhouse on a Saturday morning without calling ahead a 3-hour drive from Seattle, which told me the trip had been planned with some urgency. Rebecca was 48 years old, a hospital administrator with Rick's high forehead and his habit of pressing her lips together when she was calculating what to say next. She sat across from me at Kate's kitchen table and folded her hands on the surface. And I thought, she has been coached. "Mom," she said, "Dad's attorneys have told him that if this goes to a full hearing, it could take years. He's 76. The stress alone." "Rebecca," I said, "did your father send you here?" She hesitated. "One beat too long. I'm here because I'm worried about both of you. Your father transferred our marital home into a shell company while we were still married," I said, keeping my voice even. "He did it after he had already decided to divorce me and before he filed. There are emails that prove his intent. I'm not pursuing this out of spite. I'm pursuing it because it was fraud." Rebecca's expression shifted a brief flash of something that might have been surprise, or might have been the realization that I knew more than she had expected. "Dad says those emails are being misrepresented." "Then his attorneys can explain that in court," I said. She stayed another hour, circling the same points. She never raised her voice. Neither did I. When she left, she hugged me in the doorway, a stiff, obligatory embrace, and I watched her car disappear down Kate's gravel drive and felt a specific sadness that was different from anger. My daughter had come not to support me, but to manage me. That was who she had become, or perhaps who she had always been, when tested. The more aggressive response came 4 days later. Rick's lead attorney, Graham Sullivan, sent a letter to Diana threatening a counter motion alleging that my post-judgment filing was frivolous and constituted harassment, and that they would seek attorney fees as sanctions. It was a standard intimidation maneuver, Diana told me, designed to make the cost of continuing feel prohibitive. She responded with a 5-page brief citing case law and the specific statutory basis for our fraud claim. That same week, Andrew called again. This time, his approach was different, less dutiful, more pointed. He told me that if I continued the legal action, the family relationship as it stood could not be maintained. He said the grandchildren had been confused and upset. He said Lisa Brennan and the use of her name was deliberate, I understood, meant to signal that she was now a permanent fixture, had been unfairly maligned, and he hoped I would consider everyone's feelings. I listened to all of it. Then I said, "Andrew, I hope you kept a copy of everything your father told you to say, because if this reaches court, the jury will want to understand the full picture of how Rick communicated with his family during these proceedings." The line went very quiet. "I'm not threatening you," I said. "I'm informing you. There's a difference." He didn't call again after that. Not for a long time. The court hearing on the injunction was held in mid-August. Rick appeared in person the first time I had seen him since the original hearing. He looked well. Slightly thinner, perhaps, but well. He sat with Graham Sullivan and 2 other attorneys, and did not look at me once during the proceeding. The judge reviewed the exhibits, heard arguments from both sides, and maintained the injunction. It was not a final ruling. The full hearing on the fraud motion was scheduled for February, 8 months away. But maintaining the injunction was significant. It meant the court took our case seriously enough to preserve the status quo. When we left the courthouse, Rick passed within 5 feet of me in the corridor. He still didn't look at me. I noticed his hands were clenched. Diana walked me to my car. They'll try something else before February, she said. They always do. Let them, I said, and I meant it. But I was also tired in a way that went deeper than a night's sleep could fix. I drove back to Kate's house and spent 3 days doing very little, reading old paperbacks Kate had stacked in the hallway, walking the field behind her house in the early mornings, letting myself be simply a person who was cold and tired, and who had done everything she could for now. I needed those days. The hardest parts were still ahead. The offer came through Diana's office in early October. Rick's attorneys proposed a revised settlement. They would transfer $650,000 to me in exchange for my dropping all litigation and signing a comprehensive release of claims. That was roughly $365,000 more than I had received originally. They framed it as a gesture of goodwill. Diana brought it to me without recommendation, which I respected. She laid the documents on her desk and let me read them in silence. I read carefully. The release language was thorough. It covered not only the current fraud motion, but any potential future claims against Rick personally, against Laurelwood Properties LLC, and against Lisa Brennan. It included a non-disparagement clause that would have prevented me from discussing the circumstances of my divorce with anyone outside of immediate family and legal counsel. It required me to sign within 14 days. I set the papers down. He's worried, I said. Yes, Diana said. If he weren't worried, he'd be offering nothing. Also, yes, Diana said. I thought about $650,000. I thought about it genuinely. I was not a fool, and I was not so righteous that I would dismiss the practical reality of money when you are 74 years old with no income and mounting legal costs. $650,000 would secure the rest of my life comfortably. It would relieve the anxiety that woke me at 3 a.m. some nights, the quiet arithmetic of how long my savings would last. But the non-disparagement clause, the release that covered Lisa Brennan, those weren't provisions designed to give me a fair outcome. They were provisions designed to seal a fraudulent transaction behind a legal wall so that no one, not now, not ever, could examine what Rick had actually done. And underneath the practical calculation was something I had not expected to feel so clearly. It mattered to me that the truth existed on the record, not just in my memory, or Kate's kitchen, or Diana's files, but in a court document, acknowledged, established, real. That mattered. I had spent 48 years being Rick Thornton's wife, and for the last of those years, I had been managed and deceived and legally outmaneuvered while he smiled across the breakfast table. I wanted the record to say what had happened. I wanted that more than $650,000. I'm declining, I said. Diana nodded. She did not look surprised. I'll send the formal rejection within the hour, she said. I walked out into the October afternoon, the air crisp with the first hint of autumn, and felt something I had not felt in a long time. Not hope, exactly, but something close to it. Certainty. What I did not expect in the weeks that followed was how much I needed other people. Not counsel, not strategists, just people who understood, in the marrow of their experience, what it meant to be where I was. Kate had given me shelter, but Kate's life was small and quiet in ways that, over time, began to feel like a kind of soft pressure. She worried about me constantly. She asked how I was sleeping too many times a day. Her care was real, but it was also quietly one more form of being managed. It was Diana who mentioned almost offhandedly that there was a support group that met on Wednesday evenings in Portland. Women over 60 navigating major life transitions, often including late-life divorce. It met at the community center on S.E. Hawthorne, facilitated by a clinical psychologist named Dr. Rachel Moore. Diana said she had mentioned it to other clients. She said nothing more about it. I went the following Wednesday. There were 11 women in the group. They ranged in age from 62 to 81. They met in a meeting room with folding chairs arranged in a rough circle, a table with a coffee urn, and a box of cookies that was always the same brand. Dr. Rachel Moore was 58, with gray-streaked hair and a quiet authority I found immediately reassuring. I was not accustomed to speaking about my life in a group, but I listened first. And what I heard was a kind of testimony women who had been dismissed and surprised and diminished, who had rebuilt not through some cinematic surge of strength, but through the slow, often boring work of continuing to show up for themselves. A woman named Sandra, who was 70, had left an abusive marriage at 65 and now worked part-time at a Goodwill store and lived in subsidized senior housing. She said, "I thought I was too old to start over. But the day I walked out, I felt 20 years younger. Fear makes you old. Freedom makes you young." A woman named Phyllis, 77, was fighting her late husband's family over an estate they had tried to exclude her from entirely. She had sued, won, and gotten the money back, but her stepson had cut off all contact. She hadn't seen her grandchildren, his kids, in 5 years. After the third meeting, Phyllis walked out with me to the parking lot and said, "You've got that look." "What look?" I asked. "The one where you're still in the thick of it, but you've already decided you're going to come out the other side," she said. "I recognize it. I had it." She paused under the streetlight. "You need to be ready for the possibility that winning in court means losing in the living room. I'd do it again. I had to, but I'm not going to lie to you. It cost me." I looked at her. "I know," I said quietly. "Then you're already braver than most," she said. I drove back to Kate's house that night and sat in the dark car for a few minutes before going in. Had I already decided? Yes, I supposed I had. And knowing it was written on my face somehow made it more real, like a promise I had made not just to myself, but to the version of myself that those women in that circle could already see. I was not alone. That was the thing I had forgotten. I was not alone. That same week, an envelope arrived at Kate's house. No return address. Postmarked Portland. Inside was a single sheet of paper, typed in all caps, "You're destroying a family. Rick has a heart condition. If he dies from the stress, it's on you. Drop this before it's too late." My hands shook as I read it. I showed it to Kate. She looked at it for a long moment, then set it down on the kitchen table. "This is what abusers do," she said quietly. "They make you responsible for their choices." I filed a police report that afternoon. I forwarded a copy to Diana. Diana's response was immediate. "This helps us," she said. "It shows they're desperate." But that night, alone in the guest room, I let myself feel what I had been holding back. Fear. Real, sizable fear. Not of Rick, not of the lawsuit, but of the possibility that I would win everything legally and lose my children in the process. That the price of being right would be a silence where my family used to be. I sat with that fear for a long time. And then something happened that I had experienced before in difficult years. The fear began to change into something else. It hardened, the way sugar hardens when the temperature drops, into a clarity that was almost uncomfortable in its precision. I had not created this situation. I had not deceived anyone, restructured any assets, or recruited my children to deliver strategic messages. I had been acted upon, and I had chosen to respond. The fear was real, but so was everything else. I picked up my phone and called Sandra from the support group. She answered on the second ring, and I told her what had happened. She listened without interrupting. "Good," she said when I finished. "You held." "I held," I said. "That's all it takes," she said. "Every single time." November arrived slowly. The days grew shorter. The rains came heavier. And somewhere in those gray weeks, I stopped waiting for permission from my children, from Rick, from anyone to do what needed to be done. Dr. Rachel Moore said something in Group 1 Wednesday evening that stayed with me. We had been talking about anger, and I had admitted I was angrier than I expected to be. "Good," Rachel said. "Anger tells you something was taken that mattered. Don't rush past it. Let it teach you." I thought about that on the drive back to Eugene. I had been raised to be calm, to not make scenes, to manage my emotions in ways that made other people comfortable. But Rachel was right. I hadn't been raised to be calm. I had been raised to be convenient. That was different, and I was done being convenient. The trial was set for February. 4 months away. Diana filed motions, gathered evidence, prepared witnesses. I read everything she sent me. I asked questions. I learned the law the way I had once learned to teach Shakespeare to teenagers who thought they hated poetry by paying attention, by asking what mattered, by refusing to accept that complexity was the same as impossibility. Rick's attorneys filed motion after motion, requests for delays, objections to evidence, challenges to witness testimony. Diana responded to every single one, and I waited. Not passively, not helplessly, but with the patience of someone who had already decided how this story would end. The Multnomah County Courthouse stood on SW 4th Avenue, a stone building with tall windows that let in the February light. I arrived early, dressed in a navy blouse and gray slacks, my hair pulled back in a simple knot. Diana met me at the entrance, briefcase in hand. "Ready?" she asked. I nodded. "Ready." Judge Lawrence Bennett presided, a man in his mid-60s with silver hair and a reputation for no-nonsense rulings. He called the court to order at 9 a.m. sharp. Diana's opening statement was calm, factual, devastating. She walked the jury through the timeline. Our 4-8-year marriage, the $3.8 million house, the LLC formed April 22nd, the divorce filed August 18th. Then she showed them the email. The one dated February 14th, 6 months before Rick filed. Rick to Graham Sullivan, "I need the property secured outside the marital estate before I file. Lisa says the Portland market is peaking and I want to move quickly." She let it sit on the screen for a long moment. "This is not a family dispute," Diana said, her voice clear and steady. "This is theft. This is fraud. And the evidence will show that Richard Thornton knew exactly what he was doing." Graham Sullivan's opening was different. Emotional. Personal. He spoke of a confused husband, a complicated marriage, a wife who had misunderstood estate planning for something more sinister. Rick Thornton loved his wife for 48 years, Graham said, his voice heavy. He provided for her. But sometimes, marriages end. And sometimes, emotions cloud judgment. Several jurors shifted uncomfortably. I kept my face neutral, though my hands were clenched in my lap. Diana's first witness was a bank officer from Umpqua Bank. He testified to the account restructuring joint savings transferred into LLC accounts. $420,000 moved out in the 6 months before Rick filed for divorce. Diana entered the bank statements into evidence, each transfer highlighted in yellow. The jury passed them around, their expressions hardening as they reviewed page after page. On cross-examination, Graham asked, "Is it possible that Mr. Thornton had legitimate estate planning reasons for these transfers?" "It's possible," the bank officer said carefully. "But we have no record of any such documentation. No signed forms, no notes in his file. For amounts this large, we would typically require written authorization. But you didn't require it in this case?" The accounts were in Mr. Thornton's name. Legally, he could transfer funds without additional authorization. Graham nodded, satisfied. But Diana rose for redirect. "Sir," she said, "when a spouse transfers over $400,000 out of joint accounts 6 months before filing for divorce, without informing the other spouse, what would you call that?" The bank officer looked directly at the jury. "I'd call it suspicious," he said. On the second day of trial, Diana called Martin Liu to the stand. He was a forensic accountant, a quiet, meticulous man in his 50s who specialized in financial fraud cases. He had prepared a 40-page analysis of Rick's financial activities over the 30 months preceding the divorce filing. The picture it painted was detailed and damning. A systematic, deliberate effort to remove the primary marital asset from the estate before the divorce was filed, undertaken with full knowledge of the legal consequences. Martin walked the jury through the timeline, the transfers, the LLC formation, the coordination with Lisa Brennan, who had advised on property valuation strategies. Then Diana entered the emails into evidence. The courtroom went still as the first email appeared on the screen mounted beside the witness stand. Rick to Graham Sullivan, February 14. "I need the property secured outside the marital estate before I file. Lisa says the Portland market is peaking and I want to move quickly." A woman in the gallery gasped. One of the jurors leaned forward, reading intently. Diana let the silence sit for a moment. Then she displayed the second email. "Rick to Graham, June 3. How soon can we move forward? I want this done before she suspects." The third email was worse. "Graham to Rick, July 10. LLC is established. Property transferred. You can file any time." Something flickered across the courtroom. I watched Rick's face. It had gone completely blank, a mask of controlled neutrality. Graham whispered something urgent to him. Rick shook his head, jaw set. Graham objected repeatedly. privileged, out of context, prejudicial, but Judge Bennett overruled him each time. These emails are directly relevant to the question of intent, the judge said. The objection is denied. When Martin stepped down, the jury looked at Rick with something close to disgust. Diana's next witness appeared via Zoom on a large monitor wheeled into the courtroom. Kate, my sister. I hadn't known she would testify. She appeared on the screen from her living room in Eugene, dressed in a simple blue sweater, her gray hair pulled back. Her face filled the monitor lined, weary, but her eyes were sharp. Diana asked her gently, "Miss Thornton, did your brother-in-law Rick speak to you about the divorce in the months after he filed?" Kate nodded slowly. "He called me in March, 2 weeks after the hearing. He said, 'Kate, you need to talk sense into your sister. She's getting $285,000. That's generous.' What did you say?" I said, "Rick, you've been married 48 years. You have a $3.8 million house. How is $285,000 generous?" What did he say? Kate's voice was steady, but I could see the anger underneath. He hung up on me. Diana paused. Did he seem concerned about Evelyn's welfare? Kate looked directly into the camera. Her voice broke slightly. No, he seemed concerned about his money. The courtroom was silent, except for the faint hum of the monitor. I sat in the gallery, tears streaming down my face. I hadn't known Kate would do this. I hadn't known she had kept that phone call to herself all this time, waiting for the moment it would matter most. Graham had no questions for Kate. Judge Bennett called a recess. Diana walked me out into the hallway. "You didn't tell me," I said, my voice shaking. "She called me 3 weeks ago," Diana said quietly. "She said she had something to say, and she wanted to say it under oath." I looked back at the monitor through the courtroom doors, where Kate's face still lingered on the screen. "Thank you," I whispered, though she couldn't hear me. On the third day, Diana called me to the stand. I walked slowly to the witness box, placed my hand on the Bible, and swore to tell the truth. I wore the same navy blouse from day one, and around my neck was a thin gold necklace Rick had given me on our 10th anniversary. Diana began gently. "Mrs. Thornton, how long were you married to Rick?" 48 years, I said. My voice was steady. "We married in 1976. He filed for divorce in 2024. Tell the jury about the last year of your marriage." I took a breath. Rick was diagnosed with atrial fibrillation and congestive heart failure in April of 2022. By 2023, he needed regular monitoring. I drove him to every cardiologist appointment. I managed his medications, blood thinners, beta blockers. I made sure he took them on schedule. I paused. I thought we were facing his illness together. I didn't know he was planning to leave. "When did you discover the letter in his truck? The birthday card signed L? December. I was looking for the registration after a fender bender. The card was in the glove compartment. What did you do?" "Nothing, at first." I watched. I waited. I tried to understand. My voice wavered slightly. And then one morning in February, he told me he wanted a divorce. Diana handed me a copy of the February 14th email. "Can you tell the jury what this says?" I read it aloud. My hands trembled, but my voice didn't. "I need the property secured outside the marital estate before I file." "Mrs. Thornton, when Rick wrote that email in February, were you still living together?" "Yes." "Were you still caring for him?" "Yes." "Did you have any idea he was transferring the house into an LLC?" "No," I said. "None." Graham's cross-examination was aggressive. "Mrs. Thornton, isn't it true that you and Rick fought frequently in the last years of your marriage?" "No," I said. "We didn't fight. I didn't know there was anything to fight about." "You had no idea your marriage was troubled?" I paused. Then I spoke with full clarity. "I knew my husband was distant. I didn't know he was restructuring our assets to exclude me. I didn't know because I trusted him. I looked at the jury. That was my mistake. It won't happen again." Graham tried to interrupt. Judge Bennett stopped him. "Let her finish." I continued. "You want me to say I should have seen it coming, that I should have been suspicious, guarded, but I was his wife. I loved him. I believed in the vows we made. If that makes me a fool, then I was a fool. But it doesn't make what he did legal. And it doesn't make it right." The courtroom went silent. Graham had no further questions. Then it happened. Graham was arguing that the LLC had been formed for estate planning purposes. Judge Bennett asked for documentation supporting this claim. Graham referenced a letter from a tax attorney. Judge Bennett leaned forward. Mr. Sullivan, if this was estate planning, why do the emails specifically reference securing property outside the marital estate? Graham started to answer. Rick interrupted, loud enough for the courtroom to hear. Because it was mine. Graham grabbed his arm. Rick shook him off. Mr. Thornton, Judge Bennett said, his voice sharp. Your attorney is speaking. Rick stood. His face was red. I built that house. I paid for it. She wants to take everything I worked for. Mr. Thornton, sit down. Judge Bennett's voice was ice. One more outburst and I will hold you in contempt. Rick sat. His hands were clenched on the table. His jaw was set. I watched from the witness stand. I did not look away. Diana whispered to me later, as I stepped down. He just convicted himself. Judge Bennett took 21 days to issue his written ruling. It was a Thursday, late February, and I was at Kate's kitchen table drinking coffee when Diana called. She had received the written opinion from the court at 8:30 inches the morning and had read it through twice before calling me at 9. I will tell you what she told me, in the order she told me. Judge Lawrence Bennett had found, by clear and convincing evidence, that Richard Thornton had engaged in fraudulent conveyance of marital property prior to the divorce filing with intent to deprive Evelyn Thornton of her equitable share of the marital estate. The formation of Laurelwood Properties LLC was found to have been undertaken in bad faith, with full knowledge of its impact on the divorce proceedings. The February emails were cited extensively in the opinion. The original settlement was vacated. The house on Laurelwood Drive and all assets held within Laurelwood Properties LLC were ordered returned to the marital estate for proper equitable distribution. Based on Oregon's equitable distribution standards, Rick was ordered to pay me 65% of the total marital estate, a figure, after accounting for all assets, that came to approximately $2.6 million, including the house or its equivalent cash value if it were to be sold. Graham Sullivan was referred to the Oregon State Bar Disciplinary Committee for review in connection with his role in the original asset transfer strategy. Lisa Brennan was named as a knowing participant in the fraudulent conveyance scheme and was ordered to provide an accounting of all professional services she had rendered to Rick during the period in question. A separate civil claim against her was possible, Diana noted, if I chose to pursue it. I sat at Kate's kitchen table with the phone to my ear and looked out the window at the field behind her house, where the light was coming through the trees at the angle it only does in late winter. Evelyn, Diana said. Did you hear all of that? Yes, I said. I heard every word. I thanked her. I told her she had been extraordinary. She said the evidence had been extraordinary and that my own preparation had made her job considerably easier. We agreed to speak again the following day to discuss implementation steps. I set the phone down. Kate was in the doorway. She had heard enough. I stood up and she crossed the kitchen and we held each other the way sisters do, not elegantly, just completely. And I felt, for the first time in what seemed like a very long time, the specific relief of a burden that has been set down after being carried so long you had stopped noticing its weight. We didn't speak for a long moment. There was nothing that needed saying that the silence couldn't hold better. Kate finally pulled back and looked at me. Really looked, the way she had been doing since we were girls, and her eyes were bright and her chin was steady, and she said very quietly, Mom would have been proud of you. I had to look away after that. Not because it hurt, but because it was too large to receive all at once. I went to the window and stood there for a while, watching the field. The grass was just beginning to turn green. Spring was coming. I thought about the cherry tree on Laurelwood Drive, the one Rick had planted the year Andrew was born. Whether anyone would notice when it bloomed this year. Whether anyone in that house would think to look. And then I let the thought go. Some things you release, not because they stop mattering, but because holding them no longer serves you. That was a Thursday. On the following Monday, at 9:47 inches the morning, my phone rang with a number I did not recognize, a 503 area code, Portland. I answered. The man on the line identified himself as a physician at Legacy Emmanuel Hospital. He spoke carefully, in the way that hospitals train people to deliver news. Rick had been found at the house on Laurelwood Drive by a neighbor, Mrs. Huang, who had seen the front door standing open on Sunday morning. He had been unresponsive. He had been transported to the hospital, but there had been nothing to be done. He had suffered an acute myocardial infarction, a heart attack. The medical examiner estimated the time of death as Friday evening. He had been clearing branches from the cherry tree. Physical exertion had likely triggered the event. He had been alone. Lisa Brennan had been in Bend, attending a design retreat, and had not responded to messages. He was 76 years old. He had died 4 days after the ruling. I stood in Kate's hallway with the phone in my hand after the call ended, and I stood very still for a long time. What do you feel when the man who wronged you dies? I have thought about this question many times since. The answer is not simple, and I am not going to make it simple for the purposes of this story. I felt grief. Real complicated grief for the man he had been before he became the man he was at the end. The man who had proposed to me on Cannon Beach. The man who had planted a cherry tree the day our son was born. The man who had built bookshelves for me and promised we would last. I felt the particular hollowness of anger that has no object left to act upon. And I felt, underneath both of those things, a sober recognition that the ruling stood. Rick's estate was now subject to the same legal obligations he had been. His death did not erase the judgment. It complicated the implementation, but Diana had assured me in a follow-up call that afternoon that the estate proceedings would honor the court's order. I went back to Kate's kitchen table. I poured a fresh cup of coffee. I sat with all of it, the grief, the relief, the strangeness, and did not try to resolve it into something neater than it was. Some things cannot be made neat. That doesn't mean they cannot be survived. The estate proceedings took 13 months. Rick's death had not simplified things. It rarely does. But it had not undermined them either. His estate was administered by an executor appointed by the probate court, and the executor was legally obligated to honor the judgment against the estate. Laurelwood Drive was listed for sale in the spring. It sold in June for $3.95 above the initial asking price. And from the proceeds, my court-ordered share was transferred to my account, $2.6 million. After 13 months of estate proceedings and legal fees and the kind of patience that you discover you are capable of only when there is no alternative to being capable of it, I was 75 years old. I had, once again, a future. I did not stay in Oregon, not in Eugene, not in Portland. I had made that decision somewhere in the long months of waiting quietly, without drama. The house was sold. Rick was buried in the cemetery where his parents were buried, a plot he had purchased years before. I attended the graveside service briefly and at a distance, because 48 years required some acknowledgement, and I am not a woman who refuses acknowledgement. I stood at the edge and said goodbye to the man I had married, which was not the same man who had died. And then I got in my car and drove away. Lisa Brennan faced a separate civil claim. Diana pursued it on my behalf. Lisa was ordered to return $275,000 the fees she had been paid for consulting on the asset transfers plus damages. Her interior design business lost several major clients after the case became known in professional circles. She moved to Bend permanently and changed the name of her firm. I felt nothing when I heard this. Not satisfaction, not vindication. Just the recognition that outcomes eventually tend to reflect the choices that produce them. Not always, not reliably, but sometimes, and this was one of those times. I moved to Ashland, Oregon. I had visited once, years before, on a weekend trip with Rick to see a play at the Oregon Shakespeare Festival. I remembered the quality of the light, the way it came off the mountains in the evenings. Softer than Portland light, more generous. I rented a one-bedroom apartment in a building near Lithia Park while I figured out what I wanted to own. I walked every morning along the creek. I found a library branch where I became a regular. I found a church with a small choir that needed an alto, and I joined it, though I had not sung regularly since my 40s. I found that Dr. Rachel Moore, the support group facilitator from Portland, had a colleague in Ashland who ran a similar group. I became, in time, a member of that circle too, and then eventually a volunteer sitting with women who were in the early, terrible stages of what I had been through, listening the way Sandra and Phyllis had listened to me. I made a friend named Charlotte. She was 72, a retired high school theater teacher originally from Eugene, with a laugh that came from deep and arrived unexpectedly, like weather. We walked together 3 mornings a week and went to the farmer's market on Saturdays and argued about books with the cheerful viciousness of people who take literature seriously. Charlotte volunteered at the Oregon Shakespeare Festival and had a pottery studio in her garage. She taught me that life after 70 could be expansive, not just survivable. It was ordinary. It was sustaining. It was enough. At age 76, I bought a house. A small bungalow built in the 1930s with a covered porch framed by wisteria and a view of the Cascade Siskiyou Mountains. The garden was overgrown, but I liked that. It meant I had work to do. The first thing I planted was a Japanese maple. I bought it from a nursery on the edge of town, a young tree, no taller than I was, with delicate leaves that would turn red in autumn. I planted it in the corner of the garden on a cool morning in April, kneeling in the dirt the way Rick had knelt 46 years earlier when he planted the cherry tree for Andrew. I thought about that tree. The one Rick had promised would be there for graduations and weddings and grandchildren. The one he had kept when he took the house. The one that had bloomed without me. And I thought, that tree is gone. This one is mine. Every morning after that, I watered the Japanese maple with my coffee mug, a ritual, not a practical necessity. I watched it take root. I watched its branches reach toward the sky. I watched it survive the summer heat and the winter cold. And I understood finally what I had been building all along. Not revenge, not even justice, though justice had been part of it. I had been building proof that I was still here, that I could still grow things, that age had not diminished me, and loss had not erased me. I was 76 years old. I had $2.6 million, a house that was mine, a garden I tended every day, and a tree I had planted with my own hands. I had friends who knew my name and my story. I had a sister who had stood beside me when it mattered most. I had a lawyer who had believed me when others had not. And I had, at long last, the truth on the record. Rick had tried to make me disappear. He had failed. My children and I found a cautious middle ground. Not the warmth I had hoped for, not the estrangement I had feared, but something workable and honest. Andrew never reconciled. 14 months after Rick's death, he sent one email. The subject line read, "Moving forward." The body said, "Mom, Claire and I have decided it's best if we keep some distance for now. The girls are confused, and we need to protect them. I hope you understand." I read it. I closed my laptop. I didn't reply. I had learned, by then, that some losses are part of the cost. Phyllis had warned me. She had been right. Rebecca was different. 18 months after the trial, a letter arrived. Handwritten, 3 pages, postmarked Seattle. It began, "Mom, I'm sorry. I don't know how else to say it." She wrote that she had been scared, that she had let Rick manipulate her into thinking I was the problem because it was easier than believing her father could do what he had done. She wrote that she had been in therapy for 8 months, and her therapist had helped her see that she had been protecting him at my expense. She wrote, "I know I can't undo the last 2 years, but if you're willing, I'd like to try." I read the letter 3 times. Then I sat down at my kitchen table in Ashland and wrote back, by hand, on plain stationery, "Rebecca, I love you. I forgive you. Come visit when you're ready." She came 6 weeks later. We hiked Lithia Park for 3 hours, stopped for lunch at a cafe on the plaza, and talked until the sun went down. She cried. I cried. We didn't fix everything, but we started. Before she left, she said, "You're the bravest person I know." I shook my head. "I'm just the person who didn't give up." Jennifer stayed neutral throughout. She had never taken sides, never been recruited by Rick, never pressured me to drop the case. She sent one text after the trial. "Mom, I'm glad it's over. I love you." She visited Ashland twice a year, brought her design portfolio, asked my opinion on color palettes and typefaces. We didn't talk about Rick. We didn't need to. I realized over time that Jennifer's neutrality had not been betrayal. It had been survival. And maybe wisdom. Some people can't fight other people's wars. That's allowed. In my second year in Ashland, I met a woman at the support group named Elena Martinez. She was 68, small and soft-spoken. with silver hair cut short and hands that trembled when she spoke. Her story was achingly familiar. Her husband had died 3 years earlier. His stepdaughter from his first marriage had pressured Elena to sign a quitclaim deed, claiming the house was always meant for family. Elena, grieving and confused, had signed. 6 months later, she was evicted. She had been living in her daughter's basement ever since. I went to 3 attorneys, Elena said quietly. They all wanted $5,000 up front just to review the case. I don't have that. After the meeting, I asked if we could talk. Over coffee, I said, "What if I paid for it?" Elena stared at me. "Why would you do that?" I thought of Tom's letter, of Diana's belief in me, of Kate's testimony, of every person who had fought for me when I couldn't fight for myself. Because someone fought for me, I said, and now I want to fight for you. I paid $1,500 for Elena's consultation with a local attorney. The attorney took the case pro bono after reviewing the documents. 9 months later, Elena won a partial settlement and the right to live in the home for 5 more years. When she called to tell me, she was crying so hard she could barely speak. "You gave me my life back, Maggie," she whispered. I smiled, standing in my kitchen with the phone pressed to my ear, sunlight streaming through the window. "No," I said softly. "You fought for it yourself. I just opened a door." That winter, I officially registered the Grace Thornton Fund with the state of Oregon. It was small $50,000 in seed money from my settlement. It would help 1 or 2 older women each year who were facing estate fraud or financial abuse and couldn't afford an attorney. The first grant, $3,000, went to a 74-year-old woman in Eugene whose stepson had stolen her late husband's life insurance. I wrote the check myself, signed it carefully, and mailed it with a note. "You are not alone. Fight for what's yours. You're stronger than you know." It is early spring now, nearly 2 years since Rick died, and I am sitting in my garden in Ashland. The Japanese maple is blooming again, fuller this year, its leaves unfurling in shades of green that will deepen to red by autumn. The wisteria on the porch is heavy with purple clusters. The morning air smells like soil and coffee and possibility. I am 76 years old. I have $2.6 million in the bank, a house that belongs to me, and a fund that has helped 6 women fight back against the people who tried to steal from them. I wake up every morning and make myself a cup of tea. I tend my garden. I read, I volunteer, I laugh with Charlotte. I facilitate the support group on Wednesday evenings. I visit Kate in Eugene once a month. I am not rich. I am not famous, but I am here. I am visible. I am free. People ask me sometimes if I regret the fight, if the cost, the pain, the public exposure of my family's betrayal was worth it. I tell them this: Rick spent the last years of his life protecting himself. He transferred assets, hired attorneys, recruited our children to pressure me. He built walls of legal language designed to make me disappear. To walk away from that, to let him bury the truth along with our marriage, would have been a betrayal of everything I had been. So no, I don't regret it. Rick thought I would disappear. His attorneys thought I was too old, too tired, too grief-stricken to fight back. They were wrong. I didn't win because I was fearless. I won because I refused to be invisible. I didn't win because I was strong. I won because I loved the truth more than I feared the cost. And I didn't win alone. I had Diana and Kate and Sandra and Phyllis and Dr. Rachel Moore. I had every person who believed me when I said, "This isn't right." If you are listening to this and you have ever felt invisible, if you have ever been told to accept what was taken from you, to be quiet, to not make a fuss, I want you to know you are not too old. You are not too tired. You are not too anything. The truth is powerful. Love leaves legacies, and you are stronger than anyone knows. Thank you for listening to mine. If this story stayed with you, please like this video, subscribe, and share it with someone who needs to hear it. Thank you truly for listening.
Thank you for staying with me until this point. Please comment number 1 so I know you're still here with me. And a quick notice before we continue. The next story contains some fictional elements and is created for entertainment and reference purposes only. Thank you for your support and for being here.
After my divorce at 73, I became homeless. Then a lawyer said my first husband, who I thought was dead, left me a fortune, but with one condition. Good day, dear listeners. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. I never thought that the word homeless would ever apply to me. Not at 73. Not after 41 years of keeping a house spotless, raising children, baking pies on Sundays, and believing truly, deeply believing that the man sleeping beside me was my partner for life. But life has a way of proving you wrong in the most brutal fashion. And mine chose to do so on a Tuesday morning in October when Gerald Whitmore set a manila envelope on the kitchen table, poured himself a cup of coffee, and told me our marriage was over. Gerald and I had met in 1981 at a church potluck in Savannah, Georgia. He was a trim, confident man with a salesman's smile and a contractor's hands, and I was a widow of 7 years, still finding my footing after my first husband, Robert Caldwell, had died suddenly of a heart attack in 1974. Robert and I had been young and broke and wildly in love, married only 4 years before God took him. I had grieved properly, raised my daughter Patricia on my own, and eventually allowed myself to believe in a second chance. Gerald seemed like that chance. For a long time, he was. We built a life in a modest but comfortable house on Sycamore Lane in Augusta. Gerald's contracting business did well through the 80s and 90s. I worked as a school librarian for 27 years. We took vacations to the Florida coast, attended grandchildren's birthday parties, argued about the thermostat, and did all the ordinary things that constitute a life. I was not naive. I knew Gerald had a temper, that he could be dismissive, that he sometimes treated my opinions as background noise. But I told myself that no marriage was perfect. I told myself that this was love. The first warning signs came about 3 years before the divorce, though I only recognized them for what they were in hindsight. Gerald began spending more evenings away from home, claiming late meetings with clients. He changed the password on his phone. He stopped asking about my day. Small things, the kind of things a woman of my generation learns to excuse because we were raised to keep the peace. But then came the credit card statements I was not meant to see. Dinners at restaurants we had never visited together. A weekend charge from a hotel in Charleston. I asked him once, carefully, not accusingly. He looked at me with a flatness in his eyes that I had never seen before and said, "You're imagining things, Dorothy." Dorothy. That is my name. Dorothy Mae Whitmore, née Collins, formerly Caldwell. And I was not imagining things. The envelope he placed on the table that Tuesday contained divorce papers already prepared by his attorney. He had been planning this for months while I made his meals and washed his shirts. The divorce itself took 8 months and left me with almost nothing. Our house was in Gerald's name alone, a detail from our early marriage that I had never thought to question, because why would you question such a thing when you trusted someone? I received a small settlement, enough to cover perhaps 6 months of modest living and my personal belongings. That was all. By January, I was living in a single room at the Magnolia Inn on the edge of town, a tired roadside motel that rented by the week to people in transition, which was a polite word for people who had nowhere else to go. The room smelled of old carpet and mildew. The heater rattled. I was 73 years old, sleeping on a mattress with a spring that poked through the left side, and I cried every night for the first month. Not from self-pity, I told myself, but from sheer disbelief that this was where a lifetime of devotion had deposited me. Gerald, I later heard through mutual acquaintances, had moved his girlfriend, a woman named Rhonda, 54 years old, and a former client into our house on Sycamore Lane within 3 weeks of the divorce being finalized. When Patricia told me this, she also told me what Gerald had said when someone apparently mentioned my name at a social gathering. He had actually laughed, and said, "Dorothy, she's on her own now. Nobody wants a woman that old. She should have thought about that before she got boring." I sat with those words for a long time. I let them hurt the way they needed to hurt, and then I folded them away somewhere cold inside myself and tried to think about next steps. It was on a Wednesday in late February gray skies, the smell of rain coming, that I was sitting in the small motel lobby pretending to read a magazine when a man in a dark suit walked through the door and asked the clerk at the desk if there was a Mrs. Dorothy Whitmore staying on the premises. I looked up. He was perhaps 50, with careful eyes and a leather briefcase. He introduced himself as James Hargrove, an estate attorney from Atlanta. He sat down across from me in one of the cracked lobby chairs, set his briefcase on his knees, and said, "Mrs. Whitmore, I've been looking for you for some time. Your first husband, Robert Caldwell, passed away last month." I stared at him. "Robert died in 1974, I said. He shook his head slowly. "No, ma'am. Robert Caldwell survived. He left Savannah in 1974 under circumstances I'll explain in full. He passed away on January 9th of this year in Portland, Oregon. He left an estate valued at approximately $47 million. He paused. "And you are named as the primary beneficiary." The magazine slipped from my hands. Outside, the rain began. "There is," he added quietly, "one condition. I did not sleep that night. I lay on that rattling mattress in room 11 of the Magnolia Inn and stared at the water stain on the ceiling and tried to arrange the facts into something that made sense. Robert Caldwell, my Robert, the boy who used to bring me wildflowers from the roadside because he could not afford a florist. The man who had kissed my forehead the morning he supposedly died. He had not died. He had left. And for 50 years, he had lived an entirely different life somewhere in the Pacific Northwest, apparently building a fortune while I had grieved him, buried an empty coffin in my heart, remarried, grown old, and ended up in this room. The question that kept circling back was not even the inheritance. It was simpler and more devastating. Why? Why had Robert faked his death, or disappeared, or whatever the truth turned out to be? What had I done, or not done, that made a man choose to vanish rather than simply leave? And what kind of woman does that make me to have been abandoned twice by two different men in two entirely different ways? I gave myself until dawn to grieve the version of the past I thought I had known. I sat up as the first gray light came through the curtain, made myself a cup of instant coffee on the little motel kettle, and decided to stop asking questions about why and start asking questions about what. What was the condition attached to the inheritance? What would it require of me? What were my actual options here? Mr. Hargrove had given me his card and said he would return the following morning. We had agreed on 10 o'clock. I had the intervening hours to think clearly. My immediate situation was this. I had approximately $400 remaining from my divorce settlement. My motel room was paid through the end of the week. I had no car. Gerald had kept the vehicle we had purchased together, and the judge had allowed it because the title was in his name alone. I had a cell phone on a prepaid plan, a suitcase of clothes, and a box of books and photographs that Patricia was storing in her garage. I was 73 years old, in reasonable health for my age, with mild arthritis in my left knee, and a stubbornness that had always annoyed Gerald more than any other quality I possessed. That stubbornness felt, that morning, like the most valuable thing I owned. When Mr. Hargrove arrived at 10 o'clock, he was punctual and professional, carrying 2 cups of coffee from the diner down the road, a small gesture that I noted and appreciated. We sat in the lobby again. He opened his briefcase and laid out documents in a careful, organized manner that told me he was a thorough man. Robert Caldwell, he explained, had left Savannah in the spring of 1974, not because of any emergency or death, but because he had made a catastrophic financial decision, a bad investment that had left him owing money to individuals who were not patient about repayment. He had panicked. He was 28 years old, frightened, and rather than face the situation, he had disappeared, allowing the assumption of his death to take hold naturally because he had not corrected it. It was cowardly, Mr. Hargrove said. He said this word plainly and without apology on Robert's behalf. Cowardly. Robert had eventually rebuilt his life in Oregon under a variation of his name, going by his middle name, James, and using his mother's maiden name professionally. He had entered the timber industry, made shrewd investments over decades, and died a wealthy man. He had never remarried. He had, according to documents in his estate files, kept a single photograph of me throughout his life. The condition of the inheritance was this. Because Robert had legally disappeared without a death certificate ever being formally issued, And because the legal complexities of his disappearance created a probate situation that required verification, I would need to formally attest to my identity as his original wife and lawful spouse at the time of his disappearance, submit to a review of our original marriage documents, and participate in a probate hearing in Portland within 60 days. If the probate court was satisfied, the estate would pass to me, as stated in Robert's will, which had been written 8 years before his death and updated twice since. $47 million. The number still did not feel real, but the cracked plastic chair beneath me was real, and the $400 in my purse was real, and Gerald's laughter was real. "I'll do it," I said. Mr. Hargrove nodded, as if he had expected nothing less. He explained that the estate would cover all travel costs, legal fees, and reasonable expenses during the process. He would arrange a flight to Portland. I would need to gather whatever original documents I still possessed from my marriage to Robert photographs, the marriage certificate if I had it, letters, anything that established our relationship. I knew exactly where those things were. There was a small tin box in the bottom of the storage carton at Patricia's house. I had carried it through every move of my adult life, without ever opening it, because opening it had felt like pressing on a bruise that never quite healed. Now I would need to open it. I called Patricia that afternoon. She was surprised to hear from me. Our relationship had become strained since the divorce, not because she had chosen Gerald's side, but because grief and shame have a way of making people hard to reach. I told her I needed to come by and collect some things from the carton in her garage. I did not tell her why. Not yet. I needed to understand the full shape of this before I shared it with anyone, because I had learned at 73 that other people's opinions have a way of colonizing your decisions before you have had a chance to form them properly. The tin box was exactly where I remembered, sitting in Patricia's garage on a cold metal shelf between a bag of potting soil and a box of Christmas ornaments. I opened it for the first time in decades. Inside, our marriage certificate, dated March 14th, 1970. A handful of photographs Robert and me on our wedding day, standing outside the courthouse in cheap clothes and wide smiles. 3 letters Robert had written me during a summer job he had taken in Macon before we were married, and a small pressed flower, a roadside wildflower dried to paper thinness, tucked inside a folded piece of notebook paper. I held it carefully and did not cry. I was making a plan. There was no room for crying in a plan. The flight to Portland was the first time I had been on an airplane in 11 years. Gerald had stopped wanting to travel sometime in the mid-2000s, and I had accommodated that preference the way I had accommodated so many of his preferences. Sitting in the window seat, watching Augusta disappear beneath the clouds, I felt something I had not expected. Lightness. Not happiness exactly, but the particular sensation of a door opening onto a hallway you did not know was there. Mr. Hargrove James, as he had asked me to call him, had arranged a clean, quiet hotel near the probate attorney's office in downtown Portland. The room was warm, the bed was firm, and there was a window that looked out onto a row of bare-limbed trees along a wet sidewalk. It was more dignified than anything I had inhabited in months. And I took a long bath that first evening simply because I could, and because dignity matters, even in small private forms. The probate attorney's name was Margaret Cho, a precise, composed woman in her late 40s who wore reading glasses on a chain and spoke with the careful efficiency of someone who had spent 30 years translating complicated human situations into legal language. She went through the documents I had brought with focused attention. The marriage certificate, the photographs, the letters. She noted that the handwriting on the letters matched samples in Robert's own personal papers. She photographed everything and told me that the formal hearing would be scheduled within 3 weeks, pending a standard period for any other parties to come forward and contest the probate. Other parties? I repeated. She looked at me over her glasses. Mr. Caldwell had a daughter, she said, from a relationship in the early 80s. Her name is Sandra Caldwell. She is 51 years old and lives in Seattle. She was not named in the will. I absorbed this. A daughter? Robert had a daughter somewhere without me. He had built a partial family, just not with me, and apparently not with any formal commitment to this Sandra's mother either. Has she been notified? I asked. She has, said Miss Cho. She was informed of the estate and its terms approximately 2 weeks before we located you. which meant Sandra Caldwell had known about the inheritance and about me for 2 weeks before James Hargrove had walked into the Magnolia Inn. I thought about what 2 weeks of knowing gives a person: 2 weeks to consult attorneys of her own, 2 weeks to plan. I was not paranoid by nature, but I was also no longer naive. The call came 3 days later while I was sitting in a small cafe near the hotel, eating a bowl of soup. My cell phone buzzed with an unknown number, a Seattle area code. I answered. The voice was controlled, but with an edge beneath it, like a wire pulled too tight. Is this Dorothy Whitmore? It is, I said. My name is Sandra Caldwell. I think we need to talk. She proposed a meeting. Neutral ground, she said. A coffee shop in the Pearl District. I agreed. And then I immediately called James Hargrove and told him. He was quiet for a moment and then said, "You don't have to meet with her. She has no legal standing to contest the will on her own." I know, I said, but I want to see what she wants. What Sandra Caldwell wanted became clear within the first 5 minutes of our meeting. She was a tall woman, angular. With Robert's coloring, I could see that immediately. A strange echo of a face I had loved, but with a coldness in her expression that Robert, whatever his faults, had never possessed. She had a younger man with her, whom she introduced as her boyfriend Derek, who said nothing throughout but sat with the particular alertness of someone ready to be useful in an unspecified way. "You were married to my father for 4 years, Sandra said. 50 years ago. I've lived with him, taken care of him in his final years, managed his house and his affairs. That must have been meaningful," I said carefully. "He left me nothing," she said. The wire under her voice pulled tighter. Nothing. Not the house, not the accounts, everything to you. A woman he hadn't seen in half a century. "I didn't know he was alive," I said. "That's convenient," she replied. I noticed then that she was watching my hands specifically, watching to see if they trembled. I kept them still around my soup spoon. "Sandra," I said as kindly as I could manage, "I understand this is painful, but I can't change what your father decided." She leaned forward slightly. "I think you should consider a settlement. Voluntary. Before this becomes something difficult for everyone." "How much?" I asked. She named a figure, $15 million, in exchange for me stepping back from the probate process entirely. "Let the estate fall into a default state," she explained, "where I could then bring my own claim as a de facto caregiver dependent." I looked at her for a long moment. I thought about room 11 at the Magnolia Inn. I thought about the marriage certificate dated March 14th, 1970. I thought about the pressed wildflower. "I'll need to think about it," I said. I had no intention of thinking about it, but I needed to know what she would do next. I found out sooner than expected. When I returned to my hotel that evening, I discovered that someone had gone through my room. Nothing was taken. My documents were in a lockbox at the attorney's office, but the room had been searched, subtly and professionally, a fact confirmed by the slight misalignment of items I had left in particular positions out of the old, careful habit of a woman who had learned to notice things. I photographed the room before touching anything, then called James Hargrove and then the hotel manager. The manager reviewed the key card entry log. Someone had entered the room during a 90-minute window that afternoon, using a key card that should not have existed. That was my first direct proof that Sandra Caldwell was not going to accept this quietly. James Hargrove took the hotel security situation seriously. By the next morning, he had arranged for me to move to a different hotel. Smaller, less conspicuous, paid under the estate's account in a way that would not be easily traced through public records. He also connected me with a local attorney named Paul Reston, who specialized in probate litigation because it was now clear that Sandra intended to mount a formal contest. My plan, such as it was, rested on 3 pillars. First, complete the probate hearing successfully by presenting all available documentation, establishing my identity and my legal standing as Robert's wife. Second, ensure that all evidence of Sandra's interference, including the hotel intrusion, was formally documented and placed into the legal record. Third, remain composed, patient, and visible only when it served my purpose. The documentation piece required work. James and Paul together had already assembled the estate records, Robert's will, and his financial history. What I could contribute was the personal history, the marriage certificate, the correspondence, the photographs, and something James had found in Robert's personal effects that neither of us had expected: a journal. Robert had kept a journal sporadically for decades, and in several entries spanning the late 90s and early 2000s, he had written about me, by name. He wrote about regret, with the careful, measured language of a man who had spent decades not saying what he actually felt. He wrote that leaving had been the worst decision of his life. He wrote my name as though it still carried weight after 30 years of silence. I read those journal entries in Paul Reston's office on a gray Thursday afternoon, and I held myself together with the concentration of someone diffusing something delicate. I was not going to cry in a lawyer's office. I was not going to give Sandra Caldwell's actions the satisfaction of breaking my composure. I simply nodded and said, "Can we use this?" Paul said, "Yes." The journal was part of the estate's personal effects and entirely admissible as context for the testator's intent. Sandra filed her formal contestation of the probate 2 days later, claiming that Robert Caldwell had been mentally diminished in his final years, that I had exerted undue influence somehow across 2,000 miles, having been unaware he was alive, and that his true intention had been to provide for his caregiving daughter. It was a thin argument, legally speaking. Paul assured me of this. But thin arguments still require response, still occupy time and energy, still cost money. The estate was covering my costs. Sandra, presumably, was funding her legal challenge from whatever personal resources she had. Then she escalated. On a Tuesday evening, my daughter Patricia called me from Augusta, upset in a way she was trying to control but failing. She told me that a man had come to her house that afternoon, well-dressed, polite, saying he was conducting due diligence on behalf of an unnamed estate interest. He had asked Patricia questions about my mental health, about my drinking habits, about my relationship with Robert during our marriage. He had implied, without stating directly, that there were concerns about my capacity to manage a large estate responsibly. He had then left Patricia with a business card for Derek Sandra's silent boyfriend from the Pearl District Cafe. I stayed calm on the phone. I reassured Patricia. Then I got off the call and sat in my small hotel room for a few minutes with my hands in my lap, feeling the particular quality of anger that comes not from heat, but from cold, the kind that clarifies rather than inflames. The next morning, I informed Paul Reston. He immediately drafted a cease and desist letter to Sandra's attorney, documenting this contact as potential witness intimidation. Sandra's attorney responded indignantly that Derek had made an independent personal inquiry and that his client bore no responsibility for his actions. Paul noted for the record that Derek's business card identified him as a consultant employed by a private investigations firm that Sandra Caldwell had retained 3 weeks prior. That was the second piece of direct evidence in the legal record. Sandra called me directly that evening. She had abandoned the careful control of our first meeting. Her voice was not a tight wire now. It was a blade. "You are making this very difficult," she said. "I'm simply participating in a legal process," I replied. "You don't understand what I can do," she said. "I have resources, I have people, I have history with my father that you don't have and can't replicate." "What you have," I said, "is documented witness intimidation and an unauthorized entry into my hotel room on record with the Portland Police Bureau." I had filed the report 2 days prior, quietly, on Paul's advice. "I think you should speak with your attorney before you continue this conversation." There was a long silence. Then she said, "You're going to regret this," and ended the call. But she did not contact me again that week, or the week after. In the silence that followed, I allowed myself a few days of something close to rest. Not relaxation exactly. I was not a woman who relaxed easily, and the hearing was still 3 weeks away, but I took walks along the waterfront in the mornings. I ate proper meals. I bought a small notebook and began writing things down. Not strategy, just thoughts. Memories of Robert. The particular way the light fell through the hotel window onto the floorboards at 4 in the afternoon. The fact that I was 73 years old, possibly about to change my life entirely, and still standing. That, I decided, was not nothing. The offer arrived by formal letter delivered through Sandra's attorney to Paul Reston's office on a Friday morning. It was phrased in careful legal language, but the substance was this: Sandra Caldwell was prepared to drop her contestation entirely in exchange for a voluntary reallocation of the estate, $20 million to me, $27 million to Sandra, with all legal disputes considered settled. Her attorney framed it as a gesture of goodwill, a desire, the letter said, to honor the spirit of reconciliation that Mr. Caldwell himself would surely have wished. I read it twice, slowly, in Paul's office. Then I set it on the desk. Robert Caldwell had not left Sandra Caldwell a single dollar. He had known her. He had lived near her. She had, by her own account, cared for him in his final years. And he had still left everything to me, to a woman he had abandoned half a century ago who had not known he was alive. That was not an accident or an oversight. That was a decision made by a man who had spent 50 years living with a specific regret. $27 million to Sandra Caldwell would be a direct repudiation of that decision. Tell them no, I said. Paul looked at me steadily. You understand this may make the hearing more contentious. I understand. And that Sandra has indicated she intends to bring forward witnesses to Robert's mental state in his final years. She can bring what she likes, I said. So can we. What I had, and what Sandra did not know the full extent of, was that Robert's primary physician in Portland, a doctor, Ellen Park, who had treated him for the last 6 years of his life, had already provided a written statement to the estate confirming that Robert had been cognitively clear and legally competent throughout the period in which his will had been written and updated. The last update, made 18 months before his death, had been witnessed by his attorney, his accountant, and doctor, Park herself. The mental diminishment argument was not just thin, it was going to collapse under documented medical testimony. I did not share this information with Sandra's camp. I let the letter sit, declined formally, and waited. The waiting I found suited me. I had developed over the past weeks what I could only describe as a cold clarity. Not bitterness, not hardness, but something more like what I imagined deep water felt like, pressure from all directions, but still. I walked my morning routes along the waterfront. I ate my meals. I slept more soundly than I had in years, which surprised me and then didn't, because I was no longer in the same house as a man who did not love me, and that particular weight, once removed, turned out to have been heavier than I had known. The social support, when it came, arrived from a direction I had not anticipated. In the small cafe I had begun visiting most mornings, there was a woman who sat at the corner table with a crossword puzzle every day between 8 and 9. She was perhaps 68, compact and alert, with silver hair cut close and an expression of comfortable self-possession. We had nodded at each other for 2 weeks before we spoke, the way people do when they occupy a shared space regularly, without formal introduction. Her name was Carol Beaumont. She was a retired family law judge from Oregon, transplanted from the East Coast, who came to this cafe every morning because she liked the light in the corner and the owner did not play music before noon. We talked for the first time over a shared newspaper someone had left on the counter, and the conversation moved quickly and naturally from current events to her former career to the general subject of estate litigation, at which point I told her, briefly and without dramatic emphasis, what I was navigating. She listened without interrupting, which is rarer than it should be. When I finished, she said, "You handled the witness intimidation documentation exactly correctly." Exactly. We began having breakfast together most mornings. Carol did not offer legal advice. She was careful to remain within the boundaries of friendship rather than counsel, but she listened. She asked precise questions, and she possessed the quality I most needed from another person in those weeks. She believed me without requiring me to convince her. She simply took me at my word, as a woman who knew what had happened to her and what she intended to do about it. Some morning she brought her dog, a small elderly terrier named Rutherford, who slept under the table during our conversations with the philosophical composure of a creature who had found his purpose in simply being present. I found I looked forward to those mornings with a feeling I eventually recognized as genuine comfort. The ordinary kind, made of coffee and conversation and the company of someone who expected nothing from you except that you be honest. It steadied me. I did not realize until Carol how much the preceding months had isolated me: the motel, the divorce, the shame that attaches itself to women who end up reduced by circumstances they could not fully control. I had been carrying that isolation as though it were a private condition, a personal failing. Carol's unremarkable, matter-of-fact presence reminded me that it was not. It was simply a thing that had happened, and things that had happened could be followed by other things. Across the city, Sandra was watching. I knew this because Paul told me that her investigators had been identified making inquiries at the probate court's administrative office, trying to determine the current status of document submissions, which was public record, but also the timing of my schedule, which was not. She was preparing and she was watching and she was waiting for me to make a move that could be used against me. I gave her nothing to use. The phone call came on a Wednesday, 13 days before the scheduled probate hearing, and the voice was Sandra's, but transformed, smooth now, careful, warm even, in the performed way of someone who has been coached. Dorothy, she said. First name, no prefix. A deliberate informality. I've been thinking about how things have gone between us, and I'm not proud of how I've handled this. I'd like to meet again, just the two of us. No attorneys. No, Derek. I think we got off to a bad start, and I'd like to try something different. I held the phone and looked out the window at the bare trees on the wet sidewalk. I thought, she is 13 days from losing everything she thought she was going to get. She is trying a new approach because the old one didn't work. All right, I said. Where? She chose a restaurant this time. A proper one, not a cafe. A place called Harborview, with linen napkins and a wine list, the kind of establishment chosen to project stability and seriousness. She was already seated when I arrived. In a good blazer, her hair done, a glass of water in front of her. She stood when she saw me and offered her hand, which I shook. We ordered food we were both too intent to properly taste, and then Sandra began. It started with an apology, structured, sincere-sounding, hitting the expected notes. She had been overwhelmed by grief, she said. She had acted rashly. She was sorry about Derek's visit to Patricia, sorry about the hotel situation. She said this carefully, not quite admitting to having ordered it, but implying awareness of it. She had loved her father, she said, and she had believed she understood his wishes, and she had been wrong to pursue the contest so aggressively. I listened. I ate my salad. I said, I hear you, at appropriate intervals. And then the pivot came, as I knew it would, gradual at first. She began describing her childhood, how Robert had come in and out of her life in unpredictable patterns, how her mother had raised her largely alone, how she had chosen in adulthood to build a relationship with her father despite the difficulties, to show up for him when no one else did. She was positioning herself as the dutiful, present daughter. She was not lying about these facts, I suspected. She was just selecting which facts to emphasize. He was confused in his last years, she said, more than the doctors recorded, because he was proud, and he hid it. Dorothy, I say this gently, the man who wrote that will was not entirely the man who should have been writing it. There it was, under the apology, under the linen napkins, and the careful warmth, the same argument in new clothes. Sandra, I said, setting down my fork, I appreciate you reaching out, I mean that. But I want to be clear with you about something. I looked at her directly and kept my voice even. I am not going to voluntarily withdraw from this probate process. I am not going to accept a partial settlement. I am going to the hearing in 13 days, and I am going to present my case, and I am confident in the outcome. I paused. I understand that's not what you wanted to hear. Something shifted in her face. The smooth surface cracked in small but visible ways. A tightening around the jaw. A change in the quality of her eyes. The warmth drained out like water from a tub. You're making a mistake, she said. Her voice had gone flat. You've told me that before, I said pleasantly. I have things I haven't used yet, she said. Things about the early years of your marriage to Robert. About why he left. I considered this. Then bring them to the hearing, I said. That's what it's for. She leaned forward slightly, dropping the last pretense of warmth. He left you because you were cold, she said. Because you were difficult. Because he couldn't breathe. I know this. Because he told me. My father described his first marriage as suffocating. And you apparently haven't changed. I sat with that for a moment. I let it land. The old version of me, the one who had spent 41 years keeping Gerald calm, managing moods, accommodating, shrinking, might have flinched. Might have found herself suddenly wondering if it was true. Might have offered something, conceded something, simply to make the discomfort stop. That woman was still inside me. I could feel her, but I did not let her speak. "Thank you for dinner," I said, folding my napkin onto the table and reaching for my coat. "I hope the next time we see each other is in a more formal setting." I walked out of Harborview with steady steps and did not look back. In the cab back to the hotel, I allowed myself to feel the fear that I had kept behind my ribs during the entire dinner. It was real. Sandra's threat about things she had not used yet was not nothing, and whatever Robert had said to her about our marriage could be shaded and shaped into something that sounded damning. Character assassination was a legitimate legal tactic. Even in probate court, even against a 73-year-old woman with a pressed wildflower and a marriage certificate from 1970. But I noticed, as the cab moved through Portland's lit streets, that the fear was not collapsing me. It was instead sharpening something, like cold water on a clear morning. I took out my phone and texted Paul Reston. She threatened additional evidence. "We should talk tomorrow. I'm fine." Then I looked out the cab window at the city moving past, and I breathed and I held myself together and I thought, 13 more days. The probate hearing was held in the Multnomah County Courthouse on a Thursday in late March. The room was smaller than I had imagined. From its formal title, a wood-paneled chamber with fluorescent supplements to the natural light from one high window, rows of seats that were perhaps half filled with the various parties and their counsel. The judge was a man named Whitfield, precise and unimpressed, with the patience of someone who had heard every variety of family dispute and found none of them surprising. I sat at the petitioner's table with Paul Reston. Sandra sat at the opposing table with her attorney, a man named Gregory Bell, who had the practiced composure of someone charging by the hour. Derek was in the gallery. I noted him and then set him aside. Carol Beaumont was not in the courtroom. This was not her place to be. But she had made me coffee that morning at the cafe and said, "You know everything you need to know. Just say it plainly." I thought of that. The hearing proceeded with the formal logic of legal process. Documents were entered, chains of custody established, witnesses sworn. James Hargrove gave his testimony about the estate and the circumstances of Robert's will. Dr. Reveris. Ellen Park gave her medical testimony via written deposition, clear, thorough, specific, establishing that Robert had been cognitively competent throughout the period in question. His personal attorney, who had flown in from Portland's East Hills, testified to the circumstances of the will's creation and the 2 subsequent amendments, confirming that Robert had been present, engaged, and explicit about his intentions at each signing. Then Sandra's attorney presented her case. It was, as Paul had predicted, emotionally ambitious and legally fragile. Gregory Bell called Sandra to the stand, and she gave testimony about her father's declining years, describing memory lapses and confusion in terms that were vivid but conspicuously absent of medical corroboration. Bell entered into evidence a letter which he claimed Robert had written to Sandra approximately 4 years before his death, expressing doubts about his estate plans. The letter was handwritten. Paul Reston requested time to examine the letter. Judge Whitfield granted it. Paul spent 3 minutes reading it carefully, then approached the bench. "Your Honor, I'd note that the handwriting in this document shows several characteristics inconsistent with samples of Mr. Caldwell's handwriting across multiple documented sources from the same time period, including his journal entries. I'd like to request that this exhibit be submitted for forensic document examination before being admitted." Bell objected. The objection was overruled. Judge Whitfield ordered the letter held pending examination. Sandra's composure across the room fractured in a way that was visible if you were watching for it. Her jaw tightened. She exchanged a look with Derek in the gallery, a brief, charged look that said something had gone wrong that they had counted on going right. Then it was Paul's turn for cross-examination of Sandra. He was precise and unhurried. He established through Sandra's own testimony that she had retained a private investigation firm 3 weeks before I was located, before James Hargrove had even found me, which meant before Sandra had any legal standing in the estate. He asked her calmly, why she would retain investigators before the estate's primary beneficiary had been identified. She said it was routine due diligence. He asked who had authorized access to my hotel room on the specific evening in question. She said she did not know what he was referring to. He entered the hotel's keycard log and the Portland Police Bureau report into evidence without comment. He asked her to confirm the date on which Derek had visited my daughter Patricia in Augusta. She confirmed it, apparently believing she was clarifying something. She had just confirmed on the record that a person in her employ had contacted a witness in another state during active probate proceedings. He asked her to describe, in her own words, the nature of the dinner meeting she had arranged with me 13 days prior, and specifically whether she had represented at that time that no attorneys would be present. She confirmed this. He then asked whether, under Oregon probate rules, parties to an active legal dispute are advised by their counsel not to engage in ex-parte settlement discussions without attorney representation present. Her attorney objected, sustained on that specific point. But the pattern was in the record. Then Sandra made the mistake that I think she had been building toward for weeks without knowing it. Perhaps it was the accumulated stress, or the realization that the letter was likely going to fail forensic examination, or simply that controlled anger has a way of eventually insisting on release. She turned slightly from Paul Reston's questioning and looked directly at me across the room. She was a cold, controlling woman who drove my father away, she said. Not in response to a question, simply said into the record. Judge Whitfield looked up from his notes. Paul Reston did not move or react. He simply waited. That is not responsive to any question before you, Judge Whitfield said to Sandra, with a particular careful flatness that was more devastating than anger would have been. She doesn't deserve this, Sandra said, and her voice had climbed. He hadn't seen her in 50 years. She meant nothing to him. He told me. Miss Caldwell, said the judge, you will confine your remarks to questions asked by counsel. Bell was on his feet, hand on Sandra's arm, murmuring. Sandra sat back, breathing hard. Derek in the gallery had gone very still. In the silence that followed, I sat with my hands folded on the table in front of me and looked at no one in particular. I thought about the wildflower pressed between notebook paper. I thought about Robert's journal, sitting in the court record, and the sentence I had read in Paul's office. I think about Dorothy more days than not. I wonder if she is happy. I hope she is happy. That was not the writing of a man who had forgotten me or found me cold. That was the writing of a man who had made a terrible decision 50 years ago and spent the rest of his life understanding its cost. He had not forgotten. He had simply not found the courage to come back right until the end, when he found the courage of paper and ink and legal document and sent me what he could. I felt no triumph in that room. Only something very old and very complicated settling into place, like a piece of furniture finally moved to where it should have been all along. The forensic document examination of Sandra's letter took 11 days. The report was 3 pages of technical language that reduced to a single practical conclusion. The letter was not consistent with Robert Caldwell's handwriting as established across 14 authenticated reference samples. The ink dating placed its composition within the previous 8 months. Robert had been dead for 14 months. The letter was a forgery. Gregory Bell withdrew from Sandra's representation within 48 hours of the forensic report being delivered to all parties. Attorney withdrawal in the middle of active litigation is a significant event, and it told me more about what Bell believed regarding his client's conduct than anything he would have said directly. Sandra attempted to retain new counsel. 3 attorneys declined in sequence. This, Paul told me with professional neutrality, was not an uncommon response when a central piece of submitted evidence has been determined to be fraudulent. The probate hearing reconvened for a final session, 3 weeks after the first. Sandra appeared without legal representation. Her eventual replacement attorney had withdrawn 4 days prior for reasons not stated publicly, and she sat alone at her table. She looked smaller than she had at Harborview, smaller than she had at the cafe in the Pearl District. Not smaller in a way that made me feel anything uncomplicated. She was Robert's daughter. She had presumably genuinely cared for him in his final years, whatever her motivations. But she had also submitted a forged document to a court of law, engaged investigators to surveil and intimidate, contacted my daughter under false pretenses, and orchestrated an unauthorized search of my belongings. These were not the actions of someone driven only by grief. These were the actions of someone who had decided that what she wanted was more important than the truth. Judge Whitfield did not deliberate at length. The estate's legal standing was clear. The documentation was thorough. The medical testimony was uncontested. And the only challenge to my standing had been built on evidence that had failed forensic examination. He ruled in my favor. $47 million. The estate of Robert James Caldwell passed to Dorothy May. Caldwell, my original married name, which I had set aside at remarriage and now quietly reclaimed in the relevant documents as the lawful beneficiary, per the explicit and competently expressed wishes of the decedent. I signed the final documents in Paul Reston's office that afternoon. My hand was steady. James Hargrove was present. Carol Beaumont had offered to come, but I told her this part I preferred to do quietly, and she understood, because she was the kind of person who understood such things without requiring explanation. I texted her afterward. "It's done." She replied, "Good. Rutherford and I are at the cafe. Come have coffee." I went. The legal consequences for Sandra unfolded in the weeks that followed with the institutional patience of systems that do not hurry but do arrive. The submission of a forged document in probate proceedings is a felony in Oregon under the category of fraud upon the court. The district attorney's office opened an investigation. Paul informed me that the investigators Sandra had retained were also under scrutiny for their activities, in Augusta specifically, the contact with Patricia, which had crossed several jurisdictional lines. Derek, the silent boyfriend, vanished from Sandra's life around this period. This I learned not from any official source, but from Carol, who, being a former judge with a certain network, heard various things through various channels. She mentioned it without elaboration. I did not ask for elaboration. Gerald, back in Augusta, heard about the estate. The news reached him through mutual acquaintances, as it inevitably would in a city of that size. Patricia told me he had called her to ask about it. He had been quiet on the phone, she said, and had asked 2 or 3 careful questions, and then ended the conversation without his customary breezy confidence. His girlfriend Rhonda was, by all accounts, very interested in the Sycamore Lane house. I did not call Gerald. I felt no particular desire to speak to him. What I felt when I thought of him was something that had no drama in it, a mild disinterest, as if considering a room I had once lived in and found slightly depressing, and was now glad to have moved out of. I stayed in Portland. This surprised me, but it should not have. The city was green and unhurried and possessed of a quality I could only describe as a certain civic lack of pretension, which suited me. I found an apartment in a quiet neighborhood with a view of a courtyard garden and morning light that fell the way I liked. It was the first home I had chosen entirely, for myself, by myself, without accommodation or compromise, in my entire 73 years. I bought good furniture, not extravagant. I was not a woman with extravagant instincts, but solid and well-made, chosen because I liked it. I called Patricia and told her to quit her second job. She had been working 2 jobs since her own divorce 4 years prior. She refused the money at first, as I had known she would, and I told her she had 30 seconds to change her mind before I wired it anyway. And she laughed, for the first time in a long time, and so did I. Spring came to Portland early that year, the cherry trees in pale pink profusion, the courtyard garden filling in with green. I developed routines entirely my own. Morning walks to the cafe, breakfast with Carol, an afternoon hour with a book by the window. Small things. But small things are what a life is actually made of. I enrolled in a watercolor class, something I had always deferred. I joined a book club. For the first time in decades, my days had a shape I had chosen myself. James Hargrove mentioned that Robert had left a sealed letter for Dorothy when the time is right. I did not open it for 2 days. On the 3rd morning, I made coffee and read it. 4 pages, handwritten. He apologized thoroughly, explained 1,974 without excuse, the debt, the fear, the cowardice he named plainly. At the end, leaving was the worst thing I ever did, and I never stopped knowing it. You deserved better. You always did. I put the letter in the tin box with the marriage certificate and the wildflower. Then I went to meet Carol, because the morning was still there to be used. Sandra's consequences arrived with the patience of systems that do not hurry but do complete themselves. Charged with fraud upon the court, her legal costs consumed her savings. Derek did not return. 14 months later, a suspended sentence and a fine took most of what remained. She avoided prison, but the damage to her reputation and finances was permanent. Paul informed me she had moved out of Seattle, though he did not know where she had gone. I did not ask. Gerald had separated from Rhonda the following winter. Not happy, Patricia said carefully. I did not send him anything. He was a chapter I had finished. My life was not perfect, but I had good light, good company, and the knowledge that when everything had been stripped away, I had held on to myself. That was what I was most glad of, not the money myself. That is how a woman of 73, left with nothing but a suitcase and an old tin box, ended up with everything that actually mattered. Dignity cannot be given to you by others, and it cannot be taken away by them either. Gerald could laugh, Sandra could scheme. The world could put me in a room with a rattling heater. None of it touched what I actually was. It is never too late to refuse the terms someone else has set for your life. 1 year after the probate hearing, I sat in my apartment on a Saturday morning with a cup of coffee and a book I was not really reading, and I thought about the distance I had traveled. Not in miles, though there were miles, but in the particular interior geography that only you can measure the distance between the woman who had cried in room 11 at the Magnolia Inn and the woman who now sat in a home she had chosen, with light she had arranged, living a life she had built piece by piece from wreckage. The courtyard garden outside my window was in full spring bloom. Cherry blossoms drifted past in the breeze like small blessings. Rutherford Carroll had started leaving him with me on Saturday mornings while she ran errands, and I had come to look forward to his company was asleep on the rug at my feet, snoring faintly. I had, in the year since the ruling, done several things with the inheritance that felt right. I had established a scholarship fund in Robert's name at the community college in Savannah, where he had taken night classes in the early 70s, before everything fell apart. It funded tuition for adult students returning to education after hardship. That seemed appropriate. I had quietly paid off the medical debt of 3 families in Augusta who had been patients at the school where I had worked as a librarian, families I remembered, whose children I had known, who had fallen into the particular American trap of illness and bills and compounding desperation. I did this anonymously, through James Hargrove's firm, because I did not want gratitude. I wanted the debts gone. And I had taken Patricia and her 2 children on a trip to the coast of Maine, something she had always wanted to do and never could afford. We spent a week in a rented house by the water, eating lobster and walking on cold beaches, and I watched my daughter relax in a way I had not seen her relax in years. That was worth more than the money it cost. Carol and I still had breakfast most mornings. We had become what I supposed you would call best friends, though neither of us used that language because we were both too old to need the labels. She knew me. I knew her. That was enough. I had learned something in the past year, something I wished I had understood at 23 or 35 or 50. It was this: no one can take from you what you do not give them permission to take. Not your dignity, not your sense of self, not your right to occupy space in the world without apology. Gerald had tried. He had spent 41 years quietly conditioning me to shrink, to defer, to believe that my worth was contingent on his approval. And when he no longer needed me, he had discarded me with the casual cruelty of someone disposing of an appliance that had stopped being useful. Sandra had tried. She had wielded investigators and legal threats and character assassination, believing that an old woman with $400 and a tin box could be frightened into surrender. But neither of them had succeeded, because I had refused to give them what they wanted. I had refused to disappear. I had refused to be small. I had refused to accept the story they were trying to tell about me. And in refusing, I had discovered something I had not known was there, a spine made of something stronger than I had given myself credit for, a stubbornness that was not defiance, but clarity, a belief, quiet and unshakable, that I deserved to be treated with respect, and that if the people around me would not offer it, I would offer it to myself. Robert's letter, which I had read only once and then put away, had ended with a line I thought about often. You deserved better. You always did. He was right. I had deserved better. From him, from Gerald, from a world that teaches women to endure and accommodate and keep the peace at the cost of their own lives. But here was the thing Robert had not lived long enough to understand, and that I had only learned at 73 standing in a motel lobby with a stranger offering me a second chance I had not asked for. You do not wait for someone else to give you what you deserve. You take it. You build it. You claim it as your own. I set down my coffee and looked out at the cherry blossoms and the morning light, and I thought about the question I had been asked so many times since the story became public, in the quiet ways that stories do in small communities and legal circles. What would you have done in that motel lobby if a lawyer had walked in and told you your first husband, the one you thought was dead, had left you $47 million? And my answer, now as then, was simple. I would have opened the tin box. I would have gathered my documents. I would have gotten on the plane. And I would have fought, calmly and carefully and without apology, for what was mine. Not because of the money, but because I was worth fighting for. And if you ever find yourself in a room with a rattling heater, or a marriage that has turned cold, or a child who looks at you and sees only what they can take, I hope you remember that you are worth fighting for, too, at any age, in any season, no matter what anyone has told you. You are worth fighting for.
Thank you for staying with us until the end. This story is a work of fiction, created solely for entertainment purposes. If you enjoyed it, don't forget to like, subscribe, and share your thoughts in the comments below. See you in the next video.